President Kyle for.
All right, proceed, please. Witness, you may proceed to closing. Thank you, Your Honor.
Good afternoon, everybody.
Good afternoon,
Please pardon me if I appear nervous. I am. And if I'm keeping my hands on this podium or looking at my notes from time to time to stop me from flying away from you. I hope you don't hold that against my client. To begin with, this trial really boils down in some ways to a story of a tragedy involving two families. We know, and I agree with Mr. Rubin, everything he said about Mr. Taylor. I actually want to bring these pictures out again. We know that Mr. Taylor was a good guy. Not just a good football player, a good guy, a generous guy. He gave $10,000 to his sister on her birthday. Whoever needed to stay at his home stayed there. And none of us probably could possibly imagine what his family is going through and has gone through and went through to lose such a son and a brother. We know the gruesome, horrible fate that awaited him, and there's no doubt that the people responsible for that deserve what they get. We also know the Rivera family have a son and a brother, too. Wasn't an NFL player like Sean Taylor. He's a high school football player. Wore his hair like Sean Taylor. Wore his hair like black men at the time who played football wore it. The dreads, it was cool. It's Eric Rivera and his family. We also know, and the judge is going to instruct you, as hard as this is, that when you make your decision in this case, whatever it is, you can't take those things into account. I have to repeat that because I don't know how you can do that, but you have to follow the law and you can't take those things into account. You're not supposed to take into account the fact that you feel sorry for Mr. Taylor and his family, although I'm sure you do when you vote. And you're not supposed to take into account what the Riveras could lose here when you vote. And I know you do think that when you vote. So, I'd like to move on to the facts of the case. I just said it's a story of two families. It's also a story of two plans. The first plan is what we're here for, the trial. It's the plan, a harebrained scheme of a bunch of teenagers and young men to go and burglarize the home of an NFL star and take his money. And when I say harebrained by young men, they know that this man plays in the NFL and his team's supposed to be playing in Tampa, and nobody gets on the internet or checks or reads the paper to see that he's injured and not going to be there. Nobody plans how they're going to get in the house. So this plan, such as it is there's money there, get money. But there's a second plan after the crime occurs. And this is going to be a theme here. There's a second plan that doesn't involve young dumb men. It involves 40 and 50-year-old men, prosecutors and police officers and detectives and experienced people in this system. And that plan was, we have to get confessions and we have to close this case. Now everybody's trying to say this is treated like any other case. Like Mr. Rubin says, use your common sense. This was the biggest thing going in Miami at the time. The man was an All-American, an NFL star. It was the #1 story. 4 days had gone by. I'm going to come back to the plan in a second. 4 days have gone by, and what do they have? Nothing. Nothing. Not a fingerprint, not an eyewitness, not DNA, not a blood sample. They've got zero. They don't know how many people were there, what kind of vehicle they were driving, anything. Then they get a tip. And the interesting thing about this tip is the tip says this was planned by somebody very, very close to Sean Taylor. And the tip mentions that there was a white car there. And the reason that's important is you remember Mr. Taylor's girlfriend told you that car didn't belong to either of us. It belonged to my mother. It belonged to my mother, Jackie Garcia told you, and I was using it because my car had problems. And I'd only had it for a few days. I think maybe she said a week. Use your memories on that. I know it was a short period of time. It's important because the tipster knows that the white car is there. That's not somebody who just says, I know there's always a white car there. this is somebody involved in the offense. Remember, they said it's very, very close to Sean Taylor. But all the police here is we've got some names, and they do. They have some names of people who certainly were involved. Either they were there, like my client, or they were participants in the offense. So they go to Fort Myers, but before they do, and this is where we get to that second plan concocted by the 40 and 50-year-old men, they say, we've got some young guys here, a couple of them are juveniles, Rivera and Brown, and we know for a fact that if we go to their house and knock on the door and say, excuse me, Mr. and Mrs. Rivera, we think that your son may have killed an NFL star or been involved in that. Would you mind if we question him? What do you think's going to happen? No way. No way are they going to be able to get a statement if they do that. They're going to either be confronted by a parent just slamming the door in their face or at least hiring a lawyer. And the lawyer, of course, is going to say, my client has nothing to say. They don't want that to happen because remember, they have no evidence. They have no evidence against any of these guys, let alone Mr. Rivera, who's on trial here. So they need somebody to say, I shot this guy. Somebody to say, I shot Sean Taylor. So how are they going to do this and avoid parents and lawyers? Well, they get officers involved in Fort Myers and they get this FDLE involved. And we'll come back to why they chose them in a minute, but they say, don't go to their school. Easy to figure out where he plays football and where he and Charles Wardlow and his cousins go to school. And don't go to his house, like we just talked about. Wait. Do surveillance on the home, and then pull the van for whatever reason. You can make one up. I think one officer said there might have been a light out. Others said, no, we were just told to pull it. So they're going to pull it either way. We all know that. Didn't have to be anything wrong with it. And then when you pull it, take it down to FDLE, and we'll start questioning him. Make sure you take his phone away. And anybody else that's there. Why? The answer to that is obvious. And it's an insult to your intelligence, to say the cousins had their phones or that they were released earlier. What do you think my client's cousins, who you heard from, would have done the instant they had the ability to communicate when they know he's in with detectives? And their other cousin on the other side of their family is in with detectives. What do you think they instantly would have done? Mr. Rivera, Mrs. Rivera, calling your work, texting, letting people know. Better get away. Where are they? At an office somewhere out at the airport. I don't know. I never saw it. It says FDLE on it. The instant. So the plan was we cannot let parents or lawyers get involved. Even Detective Segovia said to me, of course it's better not to have a lawyer there. I mean, the lawyer's not going to let people talk. So they've got to also take in the cousins. So I don't think they expected the cousins to be there, but they said, let's pick up everybody around the same time, and let's do it in a traffic situation where there won't be a parent around. And, if there's extra people there, better grab them up, too, because you can't have them talking. You have to take away everybody's ability to communicate. Now, they can tell you they didn't do that, so they're blue in the face, and they expect you to believe it because they wear badges. But use your common sense. Somebody would have made a call. It's human nature. You think the cousins walked out of there and went home and go, well, I'm sure everything will work out with Eric. It's not worth mentioning to his parents. Shakespeare had an expression. He had a few expressions. One was kill all the lawyers. I don't want to talk about that one right now. But he had another one that said, round up all the usual suspects. And that was a character in one of his plays said that. It's a law enforcement character. And the point of the quote is, you need to solve a crime. You just need to find a guy that you can pin it on and be done with it and move on with your job. So when Mr. Rubin says, well, why were they trying to get Eric Rivera to admit to it? We're not necessarily arguing that when they drove over with this plan to isolate people and get them away from their parents and lawyers and a means of communication, a means of leaving and take them to a place they didn't know where they were. When they got to that plan, I don't think that they had Eric Rivera in mind saying we've got it pin it on Rivera like he was some famous guy and they had a beef with him. It was whoever we can get. And then we have to wrap up the stories and make them match, which is no problem because nobody's here except for us to witness what we're doing. So who's the youngest guy they pick up out of the four? Is this a coincidence? Who's the one who's a minor? Mr. Rivera. Because remember, they said Tim Brown didn't get picked up till later. So they pick up Mr. Rivera, and they say, how are we going to assign our detectives for these interrogations so we have four guys down here? Because everybody but Tim Brown's there. Well, we're going to take the lead detective, Detective Segovia, and the most experienced detective, Detective Bellew, who was about to retire, and we're going to put him with Ding, the youngest guy, the high school kid. We're going to put them with him because He's the weakest and the easiest to break down. Now, when I say round up all the usual suspects, do they really care whether the person did it or they just want to get somebody? How do you know? You know by their actions. A lot of times prosecutors will say, how do you know somebody's guilty? You can judge by their actions. Now, they're going to say the letter, and we'll get back to that. Things that people do show what they're thinking and what their intentions are. I'll tell you why I'm making this point. If they really wanted to make sure, we think he was involved, he says he did it, we did lean on him a little bit. We don't have, we didn't record everything on tape. His parents weren't here. Let's just make sure that he actually is the guy who did it. What are some things they could have done to confirm or disprove what he was saying? And not impossible things. One thing is, supposedly he's wearing these Nike Shocks. Now this became important because you remember the detective receives this before he goes into the interviews. He receives this thing from crime scene saying, the shoe I can positively identify at that scene by brand is a Nike Shock and a Reebok. Okay, so, and they believe the Nike Shocks is what the killer's wearing. So they get Mr. Rivera, as you've seen on the portion of the interrogation that they decided to record out of the hours. They get him to say he's wearing Nike Shocks. Well, how could they confirm that Eric Rivera wore Nike Shocks? Did they ever talk to neighbors? Did they ever talk to his classmates? He played football. How about his teammates? How about kids in any of his classes? How about going to his algebra class? What kind of shoes did Rivera wear? Hey, you ever see him wear Shocks? Like these? No, there's no reason to bother to do that, because if you start doing things like that, you might get answers you don't want to hear. Like, no, he doesn't wear those. But you know who does? Fetch a hunt or something like that. But they don't really care, and again, they might get an answer they don't want to hear. Did they search his home looking for the shoes? No. Did they ask to obtain a search warrant? Did they even ask to just come to his house voluntarily and say to his parents, can we look through his closet? We're trying to check out what kind of shoes he wore. They may confirm or disprove that he was part of this. Mr. Rubin says, well, he never went back to his house. He says the shoes are in his closet. How convenient. When he's questioning him, he's very sarcastic about it. Well, we know, using your common sense, that he never had a chance to return to his house. He was arrested there that night. He hasn't been back there since. But there was no effort made to go see if they were there. There was no effort made. We heard testimony from their expert about gunshot residue. How when you fire a weapon, there's tiny little bits of material from the weapon that are left. There was no effort made to test Mr. Rivera to see if he had fired a weapon, to test his hands. He was in custody. There was no effort made, as far as we could tell from the testimony. Remember, the fingerprint guy says, I just do the areas I'm told, to see whether Mr. Rivera, because he supposedly drove this rental, and they found the rental, to see whether he left fingerprints on the dash, on the wheel, on the shifter. There's no effort to do that. So, they fed him this story. And when there became problems in the story, and I want you to pay key attention to this because I'm sure you're going to watch the video again. The biggest problem in the story they fed him is they knew what kind of gun that had been used. They knew it was a 9mm. And they were able to tell Mr. Rivera he had a 9mm, right, during the unrecorded portions of the interrogation. They call it pre-interview, but it's all an interrogation. It's all police asking a suspect question. They know what kind of gun it is, and they supply that information to him. Now, here's the problem, and this is why you see that long pause before he has to make something up. They can't tell him where he got the gun when they're feeding him the story. So they say, where did you get the gun? He has to make something up because he never had a gun. My cousin Greg. So here's a key question that you should be left with. The police aren't feeding this story, and this is the real truth. And they want to confirm it, and they want to make their case airtight. Did you hear anything about a follow-up on Greg? I asked Detective Segovia about it. We did some search to see if there was a Greg. I said, well, what? We did some stuff. Well, what? I mean, it was round and round with him on that point. Did you go into a database? Did you visit people? Did you interview neighbors? Did you interview family members? Did you check driver's license records, property records? I don't know. Do what police do? Is it important? This is a weapon used to kill a superstar. This is a homicide case, a first-degree murder case. And he says, this guy Greg gave me the gun and he's a cousin. No follow-up on that. Because he made it up. Why did he make it up? Because he didn't have a gun. They knew what kind of gun they had to tell him that he had in order to be the shooter, but they couldn't tell him where it came from. So that part was made up, and you'll see the pause where he has to create something there. me just back up a little bit here and ask you to, when you deliberate in this case, you don't have to do this. This is what the defense is asking you to do, to divide your discussion into two areas. And I'm just asking you to do this as an exercise to prove a point. First, I'm going to ask you, as hard as this is, to set aside the statements. The statement, both unrecorded and recorded, that you've heard about and viewed during the trial. And I'm not saying ignore that. That's obviously a huge part of this case. But I'm saying for the time being, when you start your deliberations, set aside those statements, and I'm asking you to discuss, all right, for the sake of argument, if we're back here deciding this kid's fate, and none of these statements were here, none of them came into evidence, he never made any statements, do we think they would have a case to prove beyond and to the exclusion of any reasonable doubt that he was guilty of first-degree murder? And look at the evidence they would have outside the statements. Why is this important? Because when we come to the reliability of the statement, you have to look at whether it's corroborated by evidence, hard evidence, okay? So you're going to look at it and say, they don't have a fingerprint that connects him to the scene. They say they have a shoe print, but remember that's based on him saying he was wearing those shoes. They don't have the shoe, okay? They don't have an eyewitness. We know there were several other men arrested. We know at least one, according to Mr. Rivera's own statement in his letter, was cooperating, but we do not have an eyewitness that corroborates his statement. Okay? We do not have. We do not have fingerprints. We don't have any eyewitnesses to the offense. We don't have any DNA evidence. And we don't have any gunshot residue. We don't have anything proving that he drove the vehicle. We don't have anything proving he ever had a gun or procured a gun or disposed of a gun. What you would have as your proof in the case would be a letter to him saying to his cousin, as like he described, part of a series of letters. This is a series, he said to Mr. Rubin. He goes, well, you're taking out copies. We're going back and forth. You know, it's a conversation that's continuing. He didn't make any effort to go try to search for those letters at the home of his cousin or procure from his possessions at the jail, procure from his possessions a letter, okay? They didn't do any of that, but they've got this isolated letter, and that would be their evidence. Now, I will admit it's a powerful piece of evidence. As a juror, you have to be looking at it saying, why would an innocent guy write a letter saying, go tell her that we're going to fuck on her people if she fucks on our people? And pardon me, I must be getting old. I'm not exactly sure what that means, but it doesn't sound very nice, right? I mean, why would an innocent guy be doing that? Well, I ask you to imagine in your mind a 17-year-old who's in jail.
Objection.
He's charged.
Overruled.
He's charged with first-degree murder. He has given a confession. Okay? He's given a confession. He doesn't know whether or not other people are cooperating against him with the state, what statements they're giving. And he knows they intend to take him to trial on that. If he's innocent, but he's got all that weighing on him, is he going to do something dumb and think maybe I can affect the outcome? Maybe I can give myself some hope here? Is he going to write that dopey letter, Eric? If you think that's a reasonable possibility, then that's another explanation for the letter. I submit to you, it's something that either a guilty or an innocent person could do. They could just say, I'm in trouble, I want out of trouble, whether they did it or not. Guilty guys don't want to face consequences, of course. They would write a letter to get out of trouble. And an innocent guy certainly doesn't want to face consequences for something he does. So he would do it too. So you would be back there saying, do we vote guilty beyond to the exclusion of every reasonable doubt based on this letter? Based on the fact that a witness of theirs says he was at a rental car place and drove off in the rental car. Let me see if I can remember this right. Leaving his own car to be driven away by a cousin of hers. And then Charles Wardlow was in the car and she was in the car. And the explanation was they had to drive it twice because the rental car place, I believe, wouldn't let somebody under a certain age take it. But then the juvenile 17-year-old drives it off, again, leaving his own car to be driven away by somebody he doesn't know when there's an adult present who could have driven the rental car away. I'm sorry if you give any value to that testimony. I'd be shocked. And keep in mind also that that testimony is directly contradicted by the daughter of the woman who rented the car, who was there, who says, I didn't even see him there, he didn't drive it off, and she told you he drove that car off. It's Charles Warlow. So that would be the evidence in their case, a contradicted statement about a rental car, which even if Mr. Rivera had driven it, which would make no sense when he has his own car there, it wouldn't prove that he was involved, that he knew about the planning for this, that he was involved in planning and executing a burglary, which led to a homicide. It would just prove that he was involved in the rental of a car days earlier. But again, it makes no sense. He wouldn't drive that car off when he has his own car there. So that would be the evidence you would have. Obviously, your vote would be not guilty. Obviously, your vote would be not guilty. It's not proof beyond a reasonable doubt. It's hardly any proof at all. It's just proof that there's a desperate guy in jail trying to get a cousin to tell somebody to shut up. It's guilt by association, knowing that he associated with people that may have committed an offense. All right, so if you put that aside and say we wouldn't vote guilty if you agree, and if you believe that's enough for guilt, then I guess we're done. But if you say we wouldn't vote for guilty based on that, then you have to get into the statements and the reliability of the statements. And the judge is going to give you an instruction on that. So this isn't me talking now, I don't have a deep enough voice to imitate Judge Murphy, but this is what Judge Murphy, I believe, is going to say. He's saying a statement claimed to have been made by the defendant outside of court has been placed before you. That would be the video, but that would also be the things the detectives claimed, as the instruction said, claimed that he said before the video, after the video, etc. Such a statement should always be considered with caution and be weighed with great care to make sure it was freely and voluntarily made. So there's two things that you have to decide. And this is just the way I break things down in my mind in the groups. You have to know your overall job, and this is part of your job as jurors, the judge is going to instruct you to do. You have to decide, this statement, was it freely made? He made it because he wanted to, and was it voluntarily made? He agreed to do it. You must determine from the evidence that the defendant's statement was knowingly, now the judge adds the term knowingly, voluntarily, and freely made. Judge will then say, in making this determination, you should consider the total circumstances. So not just, did he sign a Miranda form? Did he initial things later after he'd already told them what they wanted to hear? But the total circumstances, the traffic stop, the plan they had, where he was taken, how it was conducted, his age at the time. You're going to consider those total circumstances, and the judge will say, these will include, but be not limited to, one, whether when he made the statement he had been threatened in order to get him to make it. Things like, you realize this is a high-profile person, and your family could be in some danger here. Well, can I talk to my mom? No. In fact, we just heard the paramedics had to take your mom to the hospital. Things like that. Or two, whether anyone promised him anything in order to get him to make it. Now, the judge says including but not limited to, so it says all factors surrounding the statement. Those are just a couple of examples the judge will give you can look at. They're not limited to. Now, this is the part I would request, and excuse my sloppiness, but when you go back, I would request that you circle and underline this last portion. I'm going to read it to you. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. That is your job. The judge isn't going to say you should take that into account in how strongly you view it or how much strong the evidence is that the statement provides. You should disregard it, which takes us back to the discussion we were just having. If you have made a decision in this case that there is not enough evidence without this statement that he gave for guilt, and you believe that the statement, for all the surrounding facts and circumstances you've learned, is not freely made by him, is not voluntarily made by him, you must ignore it completely. That is a law. That's all we're going to ask you to do in this case. That's all any lawyer can ask you to do, is to follow the law. So when you're looking at the statement, your first decision has to be, was it freely and voluntarily made? And if it was, then you have to look at whether you still believe it, based on the stuff that we've talked about and are going to continue to talk about, the trickery used by law enforcement and the techniques they use. Getting back to, again, what evidence that they have to corroborate the statement or to make a case without the statement, No prints on shell casings. We heard those are an excellent source for prints. Our print analyst said that a hard metal surface is a great surface for a latent print. No prints anywhere else in the home. They made it sound like it was really impossible to get prints, didn't they? It was Mr. Rubin's got his print examiner up, and he's going through this long litany of questions. Like, well, isn't it true that sometimes you can touch things and there's no prints? And sometimes I could even put this here and there wouldn't be a print. I could put it there and there wouldn't be a print. And I had to ask, why do you guys have print examiners? How many do you have? 18. Well, why do you have them? To see if we can get prints for court. So it's a lot of cases you do find prints and you do use them in trials. The print examiner told the truth and goes, yeah, that's why they call you usually, right? So they don't have that here. The lack of evidence is held against them. They have the burden of proof. The judge will say reasonable doubt can come from lack of evidence. Again, no DNA. We heard reference of blood there, that there may have been blood other than Mr. Taylor's blood. We have no comparison to that to a suspect in the case. The shoe pattern. I want to get back to this because this is important. And now I'm kind of mixing the two areas. I'm saying the statement should be disregarded for reasons we'll come back to about the way they gathered the statement. But even if you say, all right, I'm going to believe that the statement was freely and voluntarily given. So I'm going to pay attention to it, but I still want to know whether it's true that he did this, whether he's telling the truth there. One of the things you have to look at is going back to this Nike Shox issue. They believed the murderer was wearing Nike Shox. That information was transmitted to Detective Segovia. So when they had Mr. Rivera give his story, which we contend was coached up to him, they had to have him say he was wearing Nike Shox, but they also had to have him say that he kicked the door. Because the shooter would have to be the guy that kicked the door, because it's a narrow hallway. It's unlikely another guy's going to kick the door and back away, and then the shooter's going to step forward and shoot poor Mr. Taylor. And Mr. Taylor's running out of the room by everyone's description, which makes sense. So it's got to be the same guy. So they had him say he's wearing Nike Shox. The problem is with that, it's not a, you can assist me, it's not a Nike Shox that kicked the door. And these will go back to the jury room with you, but Ms. Carruthers there is holding a print which we will agree, and anybody in their right mind would, when you look at the pictures of the Nike Shox. I'll grab that. And you look at this print.
I'll put it on the overhead.
Okay. Sorry, I'm not with the technology. Let's see if we can get up here. Well, I don't think we can have both on these, but it'll fit. Okay, so if you look at from the overhead to the picture Ms. Carruthers is holding, that's clearly a Nike Shox. So that's why they want to get that involved, is they know that somebody was wearing Nike Shox, and it probably wasn't a police officer. They don't probably wear those. So they know, all right, one of the people, the person that did this or persons, somebody's got Nike Shox on. But they have to have Nike Shox kicking the door. Now, it's going to be hard to see from here, but you're going to be able to have this back there with you to each look as closely as you want. I want you to look at this print and look at the length of it, keeping in mind that somebody's full foot would kick a door and not the corner or the side. And it's not a perfect impression. It's not going to be the whole shoe. But you're going to see from the length of this diamond pattern that there's no way it could be that shoe. Because from the length of that, it cannot be the center bridge portion. It's too long. And every other portion of that shoe contains a letter or a circle. Circles, letters. Not here. Why is this important? I think it's obvious to you, but again, if they're feeding him the story and they tell him he's wearing Nike Shox, but a Nike Shox didn't kick the door in, then obviously he's not guilty of the offense. That obviously proves that feeding him the story. Without this statement, we wouldn't be sitting here, as we've just talked about. I don't think anybody would dispute that.
Objection.
Overruled. We know the prosecutors were working with the detectives from the beginning, and that's why we keep talking about the two plans. And we know that all the stops were pulled out in this case. It wasn't treated like a normal case. We know that they helicoptered in a court reporter, not Sean here, but they helicoptered in a court reporter to take down that statement that you see on video. You see her typing away on video from Miami, instead of just getting one from down the street, a local one. So they're pulling out all the stops in this case, and they're making sure that lawyers aren't present, and they're making sure to pick these guys up in the road, and they're employing a huge number of law enforcement officers in this elaborate plan. But they couldn't turn on a phone to record it. They couldn't turn on the camera that was set up there the entire time to record it. They couldn't do that. Why couldn't they do that? Well, they've told you, we just don't do it. It's our tradition. I think a guy who punches himself in the face every day saying, why do you do that? Well, I've always done it. Okay, there's no reason, and again, I like the fact that Mr. Rubin keeps bringing up common sense. I'll ask you to apply common sense to this. Why does somebody want to keep something in the dark? Is it because they're acting honestly and forthrightly? Is it because they're following the rules and being fair and treating people fairly? Is it? We talked about jury selection, and I asked all the panelists, and people laughed about it. I said, what if during the trial there was a witness who refused to say what I wanted him to say? I said, you stole the car. He said, no, I didn't. I said, well, why don't we have the jury step out and the judge? Court reporter stop taking out her notes, the camera get turned off, and let me spend a couple hours with that witness. Then the jury comes back in. The jury comes back in, and suddenly he's saying he took the car. And I said to everybody, do you have a problem with that? Everybody said, yeah. I said, why? Don't you trust me? Now do you know why I was asking that? Now that you've sat through this trial? Now do you see what you're being asked to do by them? Trust them. It's only a first-degree murder case. They shouldn't have to record it. They can fly people in on helicopters. They shouldn't have to press play on that. You must be honest. They're cops. You just should trust them. They didn't want to get him in a computer when they arrested him, and they didn't want to take him to the Fort Myers Police Department, which was 2 miles. According to officers, not our witnesses, according to officers, 2 miles from the traffic stop, Fort Myers Police Department, across the street, Lee County Sheriff's Office. Headquarters. Video rooms, detectives, tons of people working there. Didn't want to take him there. They took him 8 miles away to FDLE. This is the Fort Myers Police Department. Downtown Fort Myers. 2 miles away. This is the FDLE. Notice all the bustling business and all the officers coming and going, all the police cars outside. 8 miles away, out next to an old abandoned airport. What is the foreseeable reason to take somebody to such an obscure location? Well, they were smart. Nobody says they're dumb. These guys have been doing this stuff for a long time. They succeeded in doing exactly what they wanted to do. Because what happened? Eric Rivera Sr. is a football coach. And he knows a lot of people in town, and he gets a call. And due to information he receives on that call from a player, he drops everything he's doing and goes to the scene of the traffic stop. But there's nobody there. So he believes that his son has been picked up by law enforcement. And he doesn't know where he is. So what does he do, and what did they foresee would happen if they did this with a juvenile, if they ran this kind of game? He goes exactly where they didn't want to take Eric Rivera, to the Fort Myers Police Department and the Lee County Sheriff's Office, where he talks to people, where he gets a supervisor out, and they say, we really don't know where your kid is. Guess what? They weren't lying. They weren't lying to him. Those guys weren't involved in it, not at a command level at least. They may have gotten, the FDLE guys may have gotten a couple of Fort Myers police cops that they know to make this traffic stop. That was their only role. Then it's FDLE and Miami-Dade working together the rest of the day. But when you go to the Sheriff's Department, he's not in the computer. You go to the Fort Myers Police Department, he's not in the computer. Now, what do we all think about when we've been the victim of a crime or something has occurred in the neighborhood or we want to report something? The first thing, is it 911? Is it, let me call the sheriff, let me call Miami-Dade Sheriff's Department? No, let's call FDLE. So that's a household name. So Eric Rivera Sr., of course, even though this family is a Fort Myers family, he doesn't know about this FDLE building out next to the old airport. Nobody does. So it's perfect. And yes, they kindly did bring him out there later, but only after they got what they wanted, only after they got him to say everything that they wanted him to say. Same reason they kept the cousins there all day. Same reason they took their phones away, and you know they did, you're not done. Okay? They would have instantly called, they would have instantly texted. It was all part of a plan. So how does that go back to this instruction on defendant's statements? You must determine from the evidence the defendant's alleged statements knowingly, voluntarily, and freely made. These statements should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. You should consider the total circumstances, including but not limited to. Total circumstances, 17, up all night, no sleep. They say they offered him food. In fact, the way they describe it, it sounds like a dream vacation. I mean, everybody every minute was offering bathroom breaks, food, Coke, talking about football. I mean, I'm sure he was having a great time. Of course, you do see uneaten pizza pieces at around 5 o'clock during a video, whatever time it was, 4 o'clock during a video, but yet they said they had fed him pizza before. But you see Detective Scobie at the beginning of the video slide away full pieces of pizza. You can look at that and watch it. So he wasn't provided food. He was sweating all day there with them working him. No food, no breaks. That's borne out by what's in the video. They also tell you the phone he always had the whole time. There's a phone on the table. Just conveniently, the video doesn't show either of them. Well, Detective Segovia, he's had a long time to prepare for this trial and to be ready for these type of questions. And he said, oh, well, I actually slid the phone to the other end of the table before the video went on, because that way it doesn't distract him when we're interviewing him. But before that, he could use the phone anytime he wanted. Do you believe that? Again, you're not stupid. Okay, so if you don't believe these things, you think he's lying about these things, and you think this kid wasn't treated fairly, you have to disregard the statement. You think it was wrong, and you think it might affect somebody's honesty and get them to admit to something that they didn't do if you tell them that their mom was in the hospital? If you tell them their family's in danger? If you tell them repeatedly you don't believe them, no matter how many times they deny it, and they're 17? We have a teacher on the panel that said sometimes, without even threats or coercion, 16, 17 high school kids just eventually tell you what you want to hear if you keep at them enough. Is 4 hours enough? Is 5 hours enough? Without food? Without breaks, without talking to your parents, without being allowed to use a phone, hearing stuff about your family? They're going to say, well, none of that stuff happened. He's making that up. Well, who's the one who had the ability to create the evidence to prove or disprove this? They did. They chose not to turn the camera on. So Mr. Rivera walking around with his own camera in case he got arrested. Guys, mind if I set this up so I can record this entire interaction? A 17-year-old, is he a lawyer? Is he a trained police officer? He wasn't even an adult. They created a secret interrogation situation away from family, away from friends, away from parents, and they chose not to record it so that you wouldn't be able to see and hear these things. Because they count on the fact that you, the jury, will say, they're police officers, I will believe them over this kid. That's what they count on. That's how the scam works. Don't buy it. Don't buy it. Why not just throw the entire thing on a recording? Then they could say, Mr. Rubin, get up here and say, play it back from the moment he got in there, from the moment he left to the moment he left, we record the entire thing. Mr. Brown says he was treated fairly. You judge for yourselves. There'd be hardly any need for debate on it. He either would have been treated unfairly, in which case he'd walk out of it, or you would look at it and say, they treated him just fine. He wanted to be there. It was his choice to give the statement. He's guilty. So who is responsible for you not having the evidence you need to make that decision? They are. The ones with the burden of proof, the state. So I ask you to take that into account and say, you don't do that. You don't conceal what you do unless you're up to dirt. And hold that against them. So if that leads you to believe that some of these things were done, you must disregard the statement. You must disregard the statement, and Mr. Rivera is not guilty. Now, Mr. Rubin's going to get back up here in a few minutes, because the way our rules work is they get to talk first, and we talk, and then they get to go last. Again, they get to go twice, and then we don't get to say anything back to what they say. But he's going to get up here in a few minutes. He's going to say, well, Mr. Brown says all these coercive things happen, and the state denies that they happen, of course. But even if they did, it wouldn't matter, because Mr. Rivera is giving them details they couldn't have known. Therefore, he must be guilty. So even if they weren't doing right, in other words, he's still a guilty guy because he's giving them stuff they couldn't have known. But I ask you to keep in mind when you hear that all of the details in his statement, and you can play it back, are stuff they either knew or they were obtaining or could obtain from the other people they were interviewing at that time. They knew the millimeter of the gun. That was established during trial. They knew how many shots were fired. It was established during trial. They had the shell cases. They knew the window was shot out. They knew the door was kicked in. They knew about the Nike shocks. They had a tip on who was involved. It was an anonymous tip. We don't know who gave it. We know somebody supposedly close to Mr. Taylor planned this, according to the tipster. And they knew they could have known from any of the other guys that it was a black SUV. All of that stuff, including the rental information, was available to them, and they either knew it for sure, we've heard from the evidence, or they could have known it. So that's bunk when they say, we only learned these things from Mr. Rivera's statement, so therefore, even if we didn't treat him fairly, even if he was up all night and we kept his dad away from all this other stuff that they, of course, deny they did, you should still believe it because we only knew these things from him. But that isn't true. That's not what the evidence is in this case. Keep in mind there were 3 other guys in that building at the same time Eric Rivera was getting worked by them. But again, none of this would be an issue if they taped the entire interaction. None of it. First-degree murder, helicoptering people in. You've been here for almost 3 weeks. But they won't tape the entire interaction because, well, we just don't do that. We just don't do that, and it's not our tradition to do it. Which leads you to believe, why isn't it their tradition to do it? But that might be a discussion for another day. So how do they bolster the statement afterwards? It's important, part of the scam, like I said, is to keep them away from legal advice and parents, and to keep them away from a place where they can be found readily. Where maybe they get interrupted. Maybe dad roars into the lawyer an hour into this and says, give me my son back or charge him. And this is his lawyer. But how do they try to fix this after? Because they're like, look, we know what we did. We're going to deny it to the jury, but if this kid has a decent defense lawyer, maybe the jury will have problems with the fact that we didn't record this. We have to bolster. We have to bolster the reliability of the statement. So what do? They have a stenographer immediately type it up. They have him initial it. They have him sign it. All that stuff. And they say to you, well, this proves the reliability. He was read Miranda warnings, even though he was told, we can't talk to you until you sign this thing. They didn't say, we're going to question you about honesty. They said, we can't talk to you. Meaning they wouldn't even answer his questions, like, when can I use the phone to call my mom? Okay, so they're saying that makes the statement reliable. And him initially, but keep in mind, this is all after the fact. Well, he believes he's already been taped the entire time. And he's already sat in a room with a couple of detectives and said, I shot Sean Taylor. Now, once you say that, there's no putting the genie back in the bottle. This is a 17-year-old mind, remember. This isn't a lawyer, a Supreme Court justice. This is a 17-year-old high school football player who's now said, I shot Sean Taylor. Does it make any difference to him at that point as he's initialing these things and signing these things? Does it make any difference? Does it make any difference when he's in court 2 years later, when he's asking the judge for a ruling on an entirely different matter, when Mr. Roof says, is your statement sure? He goes, sure, yeah. Does it make any difference? No. The key is getting him to say it any way that you can, and then he's stuck with it. He's stuck with it, and it's going to be shoved in his face for the next 6 years. But your question is, you got to go back to jump and say, how did this statement occur? Why did they do it this way? Why didn't they go to his house? Why didn't they go to his school? Or if they were going to grab him up off the street, why didn't they tape the entire, and not offer him a lawyer, and not offer him his parents? And by the way, they said you can call your parents at any time. It's ridiculous. You know that they didn't do that. You know they didn't. You know they didn't go to the pains to keep the cousins there all day and into the night. And they said around 8 or 9. The one said it might have been still light out, so they didn't say an exact time. They kept them there long enough to get Eric Rivera's entire confession to every detail that they coached, which took a while, because I'm not impugning my client, but he's not a genius. And he's up all night, so you got to feed these things to him over and over again. You got to make him understand the world's most sophisticated diagram. Make him understand that there's a pool in the back, that there's a door called the kick door, and that there's a guy at the kick door that shot him, and that there's a wall. Okay. You have to make him understand all that before you can let Dad in for a visit. When you already know you're going to be able to put him on trial for first-degree murder, then Dad gets to come in for a visit. So you know that they didn't go to all the trouble of taking everyone's phones, jumping that car in the middle of nowhere, taking him to the middle of nowhere, a place nobody knows, just to say, hey, you want to call your mom? You want to call your dad? You want to call a lawyer? That defies common sense, and again, it's treating you as if you're dumb, which you're not. Watch his demeanor in his statement. Watch how he's a robot. He's exhausted, he's given in, and he's willing to say whatever they want him to say. The next line at the end of the statement, his brothers and I were talking about this, could have been, "You're the guy that shot Kennedy from the grassy knoll, aren't you?" "Yep." "And where did you get the rifle?" "Greg." Now, I wanted to move back just briefly to the car rental place. Again, it makes no sense. It makes no sense that Miss Anderson, what she said to you, that my client drives down there in his own car and then drives away in a rental car when he's underage, and the Hertz lets him drive away in it, and then he has somebody he doesn't know drive his car. So why does it make sense? Well, when the judge is giving you instructions, and again, I'm going to quote what I believe the judge is saying. This isn't coming from me. The judge is going to say, here's some ways you can weigh the evidence. This applies to all witnesses. Remember, everyone agreed law enforcement witnesses are treated the same as other witnesses. The judge will give you an instruction on that as well. The judge is going to say, one, did that witness seem to have an opportunity to see and know the things about which the witness testified? Well, Miss Anderson, I'm just using her as an example, did. At least she claims. Did she seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Well, that's where you start running into a problem with her, because again, you're using your common sense here and saying, you're saying he drove away, but he drove there in his car. If you're going to make up a lie, then it better be a better one than that. I mean, why didn't she say Charles Wardlow drove him there and then he drove away, which would make a little more sense. Maybe she'd be a little bit more believable. Well, that's where, and the judge will also say, does the witness's testimony agree with the other testimony or other evidence of the case? It's where you compare it to Romaine Johnson. Both witnesses, you also have to ask, does the witness have an interest in how the case is decided? And this is going to apply to other witnesses as well. Did Alexia Anderson seem to be nervous? Did she seem to be intimidated? Did her demeanor seem strange to you? How would you compare it to that of Romaine Johnson? Who did you find more honest and straightforward and truthful? And you can apply your common sense to that as well as the fact that Romaine's explanation makes sense and Alexia Anderson's makes no sense to anyone. But let's apply that to some other witnesses in the case. Does the witness seem to have a stake in the outcome of the proceedings? Well, Eric Rivera Sr., I'm not going to talk to you like you dumb. It's his son. Does that mean he's lying? No. Again, you have to compare to the other evidence in the case and use your common sense. When he talks about driving around 4 miles looking for his son, do you think that's something a father would do? My client, Eric Rivera, obviously he has an interest. It's him on the hot seat. We talked about this in jury selection, but you all agreed that if he testified, you would treat him the same as other witnesses and listen to what he had to say. But on the state side, do their witnesses? We have Detective Segovia sitting in the first row right behind the prosecutors in a suit. Does he have an interest? Is it just another day on the job? Or does he want to see that there's a conviction here? Is this important to his career? Again, this is something that was unanimously agreed on in jury selection, that officers were interested witnesses in cases. They wanted to see convictions happen in cases that they investigate where they make an arrest. So I ask you to take that into account, too, when they tell you that they did everything fair, they just forgot to press play, or they don't press play because of some wacky tradition. And then all this was a coincidence on how they picked them up and picking everybody up at the same time, and they never took their phones, and they let them call their parents, and they gave pizza that's still sitting on the table hours later with not a bite out of it. I ask you to take that all into account and say, is there an interest in this case on their end? Now, Mr. Rubin says, why do they make him say certain details in the statement that are not true? Why do they make him say he was riding next to Timmy? The crowbar they did not know about. Well, Mr. Rubin says, well, you do know a lot. And here it says, yes, I know what I'm testifying to now. So there are things that are consistent between what he's testifying to in court and what he's testifying to in his previous statement. And the thing that's important about that is he's not denying that he was there. He did have some knowledge. So not only are they feeding him things from the crime scene, but he does have knowledge. He was there, he was in the house, but he was along for the trip, as you know, and he knew the parties involved, and he knew what they did after the fact. He knew what they did. So some of these things are coming from his personal knowledge, and are probably not fed to him by law enforcement. But he has to lie about things that he doesn't know and things that aren't supplied to him. Now, when it comes to Jason Mitchell's phone calls, I know the state believed this was a big aha moment, and I saw a lot of you taking notes, and it is important. But the state asked a key question, not us, but he asked a key question of Mr. Rivera. He said, you had these phone records and you reviewed them yourself, right? This is before he testified. And he said, yeah. So if Mr. Rivera is going to get up here and lie to you about not really knowing Jason Mitchell and it's about all that, when he knows there's calls back and forth between the phone, why would he do that if it's not the truth? Wouldn't it be easier for him sitting there with copies of the records, preparing to testify to say, because it really wouldn't have affected his defense if he said, I did know Jason Mitchell, we weren't particularly good friends, but he was calling me, maybe he could make something up, he wanted to date one of my sisters, I didn't want him dating my sister, we were talking about, who knows, you can think of 20 explanations in 5 minutes if you wanted to try. So if he wanted to make sure to explain those phone calls away with a lie, he easily could have prepared to do that, to lie to you. But instead he said, I don't know, I guess Wardlow was using his phone, Wardlow used my phone to call some people, they may have talked a couple of times on my phone, I don't really know. I know one thing, I barely knew Mitchell. Mitchell, of course, and Hunt being older guys. Hunt being, I think, we have it here somewhere. Yeah, here's Benja Hunt, born in '87. So these guys are 3-4 years older than Mr. Rivera. They're not friends of his. Wardlow's his friend. He doesn't know Mitchell. He knows who he is. Yeah, that's Mitchell. That's Hunt. I know who those guys are. We all live in Fort Myers. We know similar people. But he could have, if he wanted to say, oh, I better explain away these calls or the jurors are going to, think I'm lying, he could have made up any story he wanted to. But he told you the truth. Now, whether Mr. Wardlow, we have no idea. Whether Wardlow's calling Mitchell, Mitchell's calling Wardlow, maybe Wardlow's phone was dead, he had to recharge it, maybe Mitchell's was. Who knows? This is simply unknown. We can only speculate on these things. But we know he could have made something up that was a lot better if he wanted to. And he didn't do that to you. And keep in mind, too, there's a major contradiction in what the state's asking you to do here. And this is really interesting. They're saying to you, Eric Rivera is a skilled, habitual, flagrant liar. That's what he does all the time. They're saying Eric Rivera lied from day one. He lied. He said he was at the Bell Tower watching a movie. He lied he was at home with his parents. He was with his girlfriend. And then he told the truth, and then he lied again, and now he's lying in court. So what they're saying to you is he's a liar. He cannot be believed, except for the stuff that we want you to believe him about. That part's true. That's what they're saying to you. Do you see the logical inconsistency with that position? He's a liar, but we want you to believe him, because they have the burden of proof, not me. That we want you to believe him about the stuff that we want you to believe him about. Now, Mr. Rubin spent a lot of time going through this timeline. He said, at 2 o'clock, according to detectives, and I think actually Mr. Rivera agreed with this, so about 2 hours in, there's a head nod. So, they've got him on the road where they want him to be, which is he's going to be admitting to killing Sean Taylor. He's not providing details. They haven't been given to him yet. But there's a head nod. So they've got him, right? Now, their first excuse for not turning on the tape is we don't record everything. We're not going to record a guy going to the bathroom or eat his pizza, which supposedly he was doing for an hour and 20 minutes, but sitting on the table. Again, if they're lying about that, you don't believe my other stuff. It's up to you. But there's a head nod, so he's down the road where he's going to give it up, right? Okay. Why didn't you turn it on then? Because what do they need to do for the next 2 hours? First, they had to break them. That took 2 hours. Your mom's at the hospital. We won't let you talk to your parents. You're up all night. We're not going to feed you. People are rolling on you. People are saying you did it. I don't believe you. I don't believe you. You're a liar. You're a liar. I don't believe you. I don't believe you. You killed him. I know you killed him. 2 hours of that, okay? Now the head nod. Yes. We're going to get one of these guys. That's what we're here to do. Round up the usual suspects. So, you turn the recording on at 4. Why? Because it takes 2 hours to get this kid to do this. To say you had a 9mm. Remember, it's 2 shots. Remember, you fired twice, right? Because he was in the car. He never heard the shots. He heard these guys talking a bunch of nonsense on the way back. You kicked the door with your Nike shots. Whoops. Then we have during the trial, Mr. Rivera getting up here trying to tell you what happened. We have a lawyer with decades of experience twisting words, asking long, lengthy questions with 10 different questions built into one question, mocking him, person who 6 years ago was pulled out of his high school, trying to show how much smarter he is, how clever he is, how not clever, simple that Eric is. Well, he wins. He sure did that. But again, this goes back to their actions. And it goes back to the weight of the evidence, the burden being on them, beyond the exclusion of every reasonable doubt. And you disregarding that statement if you believe that he wasn't fairly treated. He wasn't fairly treated, so it wasn't a free and voluntary statement. You disregard it. Not courtroom theatrics, and not presenting 20 witnesses to say what one witness could say. This isn't about Lady Justice's scales and saying, if we pile on witness after witness after witness for a week to a homicide, we win on sheer number of witnesses. Well, we're not contesting that Mr. Taylor was murdered. We're not contesting that the people who did it deserve what they get. None of that's even contested. All this is about is Eric Rivera's statement. Who was, just a few things before I wrap up, some things that have been troubling me. Who was Jason on the phone with? When you couple this with the anonymous tip about somebody very close to Mr. Taylor, and then you couple this with, we just know Jason Mitchell was getting directions to someone, from someone, directly to this house. Who was that? Again, there's no follow-up on these type of things because it's just about wrapping it up and getting the headline. Where did the gun come from? Who kicked in the door if the Nike Shocks did not? Which guy? I mean, who was the guy who kicks in that door? I want to close by asking you to pay a little bit of attention when you go back to a few different instructions I expect the judge to give you. One thing the judge is going to say is that a mere presence at the scene of a crime does not make you a principal. So there's no mistake here. If you do not accept the statement and you reject the statement as the law requires you to do because it wasn't freely and voluntarily made, all you know is that Eric Rivera, as he's told you himself, was present in the automobile and was along for the ride when these guys did what they did. Okay, so mere proximity is not enough to convict. The judge will tell you that. That's not me. That will come from Judge Murphy. So not to be any, so there's no confusion. There's no guilt by association in this country. You had to be a planner. You had to be a participant. You had to do actions in order to make the crime happen, to be guilty of it. So I ask you to pay attention to that. I'm also going to ask you to pay close attention to the instruction the judge gives you on reasonable doubt. Don't worry, I won't read the whole thing, but I'm going to read some portions of it. And remind you, we talked about this in jury selection. Reasonable doubt is not based on, well, I think he probably did. It's not even, as we talked about, the clear and convincing evidence standard that they use to take somebody's children in dependency court. That clear and convincing, think of those words. If you're clear and you're convinced on the issue, it's not enough for a conviction in a case. Reasonable doubt is the highest standard we have. And the part I'm going to ask you to pay particular attention to is the judge is talking about what a reasonable doubt is. He's going to say first, it's not imaginary or four-step. Aliens did it. Mind control's involved. You know, and we're not saying any of that. That's dumb, okay? It's not that. It's a reasonable doubt. But the judge is going to say that here's some ways to tell if your doubt is reasonable. And this is what I'm going to ask you to pay attention to. Again, underline it if you may. It's toward the bottom of the page. The judge is going to say, if you have a conviction in your mind of guilt, if you have a conviction, but it is one which is not stable but which wavers or vacillates. So you're convinced there's a conviction in your mind that it's wavered or vacillates due to, I do want to know what happened for the hours before they finally turned on the recording so I could see what was going on. I do wonder why they did it at FDR. I mean, if he's guilty of it, I do wonder why they didn't corroborate any evidence of where the gun came from or the shoes or anything like that. If those things and the things that we've talked about cause a wavering in your mind, a vacillation, as the judge will say, that a week from now, a month from now, a year from now, you're going to wake up saying, if it causes a wavering and a vacillation in your mind, then it's a not guilty verdict. That's your job. And it's a tough job to do because that's telling the juror that even if you think a person probably did it, and it's a heinous crime, you have to vote not guilty if you have a wavering in your mind based on the things that we've talked about. That is the law. Now, some things that I just wanted to follow up on briefly that Mr. Rubin brought up, because this is my only chance to talk to you, and again, he gets to talk to you twice. Mr. Rubin said, well, these guys are planning to burglarize the home of an NFL star. Why would they bring along a witness to a burglary if Mr. Rivera is just along for the ride? I don't know. Why wouldn't they? They're idiots. They're idiots. I mean, look at their actions. They didn't even check to see if he was going to be there. He's a famous guy. Anybody could find out in 2 seconds on an iPhone or a computer. This was 2007. It wasn't 1902. Okay? They said, we're going to get money. They think there's $100,000 to $200,000 in the house because Jason Mitchell saw $10,000? I mean, they don't even have any reason to believe, which of course there was not money like that in the house. They have no reason to believe that. They have no reason to take all the people they did take. If they don't think anybody's home, why does Mr. Mitchell, who even according to them is the planner, why doesn't Mr. Mitchell just go take the $100,000, $200,000 for himself? Because he's an idiot. Or if he's going to involve Mr. Hunt, why don't those two split it? So why are they even involving Brown and Wardlow, let alone my client? Well, so there really is, the prosecutor here is asking you to decide logically as if this is an organized band of like thieves from a movie, who knows how to short circuit alarms and stuff. Why would they take an extra man who doesn't have a role? I don't know, they're idiots. Also, Mr. Rubin makes a big deal out of these tools from the yard. He explained, Mr. Wardlow, who's his best friend, we could see that, Mr. Wardlow had taken the tools and borrowed from him. Why? Wardlow fixes ATVs and works on them. It's his hobby. That's what he does. Again, Mr. Rivera didn't have to say that the tools were in the yard and they were from his house. He could have said they were from somewhere else, but he said, yeah, they're from my house, but they're Wardlow's tools. That never contradicted anything that he said before. Mr. Rubin keeps saying that Mr. Rivera was there and rented the car. Notice he didn't say he drove off in the car because he knows he hasn't established that. But he keeps saying he was there when the car was rented as if that was a fact. And this bothered me because, first of all, it's obviously not a fact. That makes no sense. It's a hotly contested issue in the case. But the state has to establish that if that did happen, which it didn't, that the person who's driving the car away, and they want you to believe it's Mr. Rivera or might be Mr. Rivera, knew that that car was going to be used in a burglary at that moment for him to be guilty. See, they're saying that he's emphasizing this point with you, and this is important because he's saying, this jury might have a problem with the crooked way the statement was obtained. They might not believe, actually, that Mr. Rivera did shoot this man, and they might not believe he went in this home. But my fallback is going to be, he's guilty because he rented the car. Don't be fooled. Don't be fooled. The instruction on principle says you have to, at the time, intend. So when he drove Charles Wardlow down there, because Wardlow said, I want to get this rental car because he wants to be able to ride around in a nice car, he has to know at the time. Wardlow would have had to tell him, I'm going to rent this because in a few days, as if these idiots pre-plan anything, in a few days we're going to go over and get money. We're going to go, what do you mean get money? We're going to go burglarize Sean Taylor's home. Sean Taylor, the NFL player? That conversation would have had to have occurred in order for Mr. Rivera to be guilty as a principal for simply being involved in the rental of the vehicle, for giving Wardlow a ride down there. Or even if he did drive the vehicle off, he would have to know that. So that's their fallback. They're trying to fall back on that and say if the jury disregards the statement because of the actions of law enforcement and the evidence isn't sufficient to prove that Mr. Rivera went in the house and fired the shot, our fallback says he was involved in the rental, so hopefully the jury will just give us a guilty based on that. Mr. Rivera said he was not handcuffed. If he's making up all this entire story about how all this pressure was applied, all the things they've said about his mom and his family, and not believing his story and feeding him the information and being up all night, why wouldn't he just say he was handcuffed? Well, why not say he was beaten? Wouldn't that even sound better? Remember, he just makes things up, according to Mr. Rubin. Well, I could think of better things, couldn't you? Why not say he was beaten? They beat him. They put a gun in his mouth. I mean, they don't have a video on him. He could have made up all those things. He told you what happened, exactly what happened, the good and the bad. No, he wasn't handcuffed. No, they're more subtle than that. They don't do every possible thing they would have done in the 1800s. They didn't beat him around with a telephone book, and stuff like that. They used psychological pressure on him and isolation because he was young, and relentless questioning because he was young, and that's what's going to work on a young guy who's not sophisticated. Mr. Emerson says there's a landline in that office usually. He did not say there was that day. He said he couldn't know one way or the other because he didn't check during the question of Mr. Rivera. And again, the video speaks for itself. No cell phone, no landline, pizza not eaten. Lie, 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 lie. After all this has been considered, and you weigh all the evidence in the case, The defense is going to ask you to return a verdict of not guilty in this case, on both counts. The defense is going to ask you to do that not because you feel sorry for him and his family, but because the way he was treated is un-American. And it's your job as jurors. You're the conscience of the community.
Objection, Your Honor. Move to strike the
Ladies and gentlemen, disregard that last statement.
You as jurors have a duty and a responsibility under the law to make the determination whether that statement counts or not. You decide whether the behavior was appropriate. You decide whether or not the statement was knowingly, voluntarily, and freely made. You decide by looking at the total circumstances. You, not them with their policies and procedures, but you get to pass judgment on that. Not just Mr. Rivera, but on the way the investigation was done. When it comes to statements, that is the law. And that's what I'm referring to. So at the end of the day, I ask you to say, he's not guilty because that statement wasn't reliable. And there's no other evidence that he committed this crime. Certainly not enough to convict him beyond a reasonable doubt on a dopey letter. Thank you very much for your time and attention.
All right, we're going to take another short break before we continue on with rebuttal and then my instruction on the law. And don't discuss the case with anyone, don't discuss the case. Together, Mr. Assemble in about 10 minutes. If we're out, we'll continue on.
All right. Ladies and gentlemen, put your tablets face down on your chairs, close them up, take all your personal belongings with you if you want, and we'll meet you in 10 minutes down the end of the hallway.
See you on 10.
You want this specifically?